So a good deal of what I'll be talking about is following on from some of the things that Esteban has just said. And then Ilaria and Esteban will take over again and add even more. And if you have any questions at any point, just feel free to ask them. So I'm going to, if my PowerPoint lets me, start talking about GDPR, which stands for the General Data Protection Regulation, which if you are based in Europe, it's kind of inevitable that you have heard about. It came into force in May 2019, if I'm not mistaken, and that was the period where you received in your email inboxes loads and loads of emails from loads and loads of newsletters you never remembered registering to, whether or not they are still allowed to contact you. That was because it was a requirement in GDPR. Now, there's a lot of, I want to say, misconceptions about what GDPR is and what GDPR does. Many companies have been very scared of it because there are really draconian fees if you breach, if you have any data breaches of up to 4% of annual turnover. For a company of like Facebook, that is a lot of money. So there's been a lot of unrest, let me say, globally with organizations who use data about this having a potential major fallouts. We haven't seen much of that in practice yet. And it looks a little bit different for research, and actually for users and for people who care about privacy, GDPR is a pretty good thing. But in terms of its purpose, GDPR is also meant to be good for business. So it's really, in its intention, GDPR is meant to facilitate the free movement of data in the European single market, so that when you have a business in Portugal and you want to interact with a partner in Sweden, you can do that seamlessly. GDPR also enshrines in law a lot of the things that are already best practice for data processing, or that have been best practice for a long time before they became law, such as privacy by design, where you essentially you don't keep the data that you don't need and you protect the privacy of your users or your research subjects or your participants by default. Things like pseudonymization, where if you don't need to have the actual names and personal details of people, you pseudonymize them, you just use the data in that format, or, you know, even better, anonymize them, and we'll get to that in a moment. It's very much about prevention of breaches rather than repercussions for breaches when they happen, because once data is out in the world, you cannot really get it back. So it's a lot about making sure that doesn't happen in the first place. It also enshrines data protection impact assessments, which is probably more relevant in a business context, but I'm going to just touch on it anyway, which are a tool to assess what potential impact a data breach would have for your organization. And it's a standardized format. It's a set of specific questions. I don't know, Esteban, whether they are implemented in your data management plan tool from the top of my head, but it'll certainly follow a similar structure. And they are just there to sort of assess what kind of security measures you should be taking. So this is what GDPR does. This is what GDPR enshrines in law and makes sure people do. There's another set of confusion around where GDPR applies. Now, first and foremost, GDPR only applies to natural persons. So Esteban and I and Sarah and Lucy, we are all natural persons, and our data is protected by GDPR. The data of King's College London as an organization, like how big the organization is, how many employees we have, that is data about an organization that is not protected. The data about these employees obviously is personal data because, again, they are persons. But it doesn't apply to organization data. It does apply to personal data. It does not apply to data about deceased persons. So once you are dead, you are no longer a natural person, therefore GDPR does not apply. Sounds a bit awkward, I know. There are other mechanisms that protect the deceased, but they are not GDPR. GDPR does make a strong difference between personal data and sensitive personal data. And again, I'll come back to that at the end, what that distinction is and what it means. That is the wrong direction. GDPR applies to anything, or it talks a lot about processing data. Because whenever data is processed, GDPR applies. Now for that, you obviously need to know what data processing is. And in a nutshell, I've put it there at the bottom, it is anything that touches the data. So collecting it, recording it, organizing it, structuring it, storing it. So simply just having it on a hard drive somewhere, adapting it, altering it, using it for anything, transmitting it somewhere, making it available to other parties, all of that is data processing. So for all of these actions, where they apply to data about natural persons, GDPR is relevant and you have to abide by the law. GDPR also makes a distinction between data controllers and data processors. I assume that this will not be too relevant for most of you because you will probably do both in one. But it's important to know the difference because it makes for a change in responsibilities, especially if you are working with any partners. Data controllers are higher up in the hierarchy. They are accountable for what happens with the data. They must comply with all of the GDPR principles and make sure that any processors they engage with do the same. So if you have collected a set of data, or you say you have data about your participants, where you have their names and their email addresses and whatever, and you want to send a newsletter to them, but you don't do that yourself because, I don't know, maybe you don't know how, maybe you just do that via a marketing agency. You are the data controller. That agency would be the processor because you would need to give some of the data to them, and it is your responsibility that they don't mess up with that data. They still have the duty of care and they are still responsible for the data, but any breaches that they create, you are still accountable for. It doesn't really matter where this processing is conducted. I've put that down here in scope. It's not, again, this is more relevant if you have big international projects. So long as you are dealing within the EU with data about EU citizens, GDPR is the same wherever. There's a slight difference if you have, if you are, say, working from outside the EU, which I assume none of you are, GDPR would still apply for data of European citizens. So even if you act from, I don't know, Brazil, and you are dealing with the European market or with natural persons in Europe, you would still have to abide by GDPR. So just being outside of Europe doesn't make a difference. Now, this is probably the hardest part and the most complex one, but it is also the most important one, because this is really how GDPR regulates how you can legally process data. And there are two articles in GDPR that are really key to this. One is Article 5, which establishes the principles under which personal data can be processed. It has to be lawful, fair, and transparent, which is kind of obvious. There is a purpose limitation. That means when you use personal data or when you collect personal data, you collect it for a specific purpose. And you can only use it for that purpose. You can't collect data of your participants in order to engage them in this particular project, and then 5 years down the line, use that same data to recruit them for something else. You just cannot do that. Another relevant principle is data minimization, which effectively means you only collect the data that you actually need. So if you only need a name and an email address, don't ask for their shoe size or, anything else. Data has to be accurate and importantly has to be kept accurate. That kind of comes with a use by date for data because you can't assume that it remains accurate in perpetuity. Goes along with a storage limitation that you cannot just keep data forever. When you don't need it anymore, you should delete it. And for integrity and confidentiality, again, the data has to be how do you say that in English? Maintain its integrity, and it has to stay confidential to the group of persons that are allowed access to it. So that is the principles. Now then we go to Article 6, which is the options for lawfully processing the data, which sort of really defines the point A in Article 5. The key way to lawfully processing data for you will be either consent or the necessary performance of a contract. The key thing will be consent because that is in general how it works in research. If you want to collect personal data from people, you have to acquire their consent. That is, I think, one of the things that also will be touched on in the data management plan in a bit more detail. But the key thing to remember is you cannot collect data about natural persons, personal data about them, if they do not consent to that. And we have, Kat, correct me if I'm wrong there, we have templates for you to do that, for consent forms that they can sign or that you can stick in front of a survey or however you collect data. But you have to acquire consent. You have to acquire consent unless you fall into one of the other categories, which again are fairly unlikely. Necessary performance of a contract, you are probably familiar with because it applies in a lot of circumstances in your life. When you buy a car, the dealership has to keep your personal details for payment and for, sending you updates and letters because you are in a contract with them, and they don't need your consent for that because you have signed a contract and that enables them to use that data for that specific purpose. They can't by default use that for any marketing, for example. Compliance with legal obligations say you have to keep your tax files for a set number of years, and that may include some personal data. Again, that may be one of the reasons. A vital interest of the data subject. This is more relevant for like public bodies and hospitals and that sort of thing. Similar for public interest. Legitimate interest is one of the very ambiguous elements at the moment. And I don't know about you, but I tend to not accept cookies on websites and really go through the settings. And recently, one thing I've seen pop up there is people either asking me to consent to the use of my data or weirdly to consent to them using it for legitimate interest, which doesn't make any sense whatsoever. But legitimate interest is really fulfilling the purpose of the organization. At one point, Facebook tried to argue that their purpose is to deliver advertisement to their users, which I don't think users would agree with, but that is one way to frame legitimate interest. And we haven't really seen court cases come down for exactly how this use pans out in practice. GDPR is fairly new. Regardless, for you, the key lawfulness factor will be consent. So what do you do about all of this? The most important thing is really to map out which data you collect, and that means both data and metadata. So if you collect data through a web form, look at what other data that form also collects, like location data or metadata in images, if you do something like that, and what you need that data for. Be very careful if you use special category data. This is the specially protected data in GDPR, and that means anything like ethnicity, religion, politics, union membership, genetic data, biometric data, health data, and sexual orientation. These are specifically protected, and my general advice would be to not collect them unless you absolutely have to. And if you do, have a proper look at the ethics of that. And your action mentor will be able to walk you through that if that is the case. Inform your data subjects, your participants, your contributors, whatever you have, about the data collection that you do, gather their consent, enable them to access, change, and remove their data if they want to. That is a key right of data subjects in GDPR. It's not enough to gather their consent at one point for one thing and then just do with the data. I mean, even if you only use it for that purpose, you have to allow them to make sure that the data remains accurate. That is part of the accuracy and integrity in the processing principles. And all of this you capture in a data management plan, which Esteban will delightedly explain to you over and over again. I have one more slide on licensing, but I want to at this point stop and see if there's any questions about GDPR. And I see that there's one. Spend a minute on this and then I'll pass on to Ilaria and Esteban. But Esteban has sort of hinted so much that I would talk about this, so I suppose I have to. This is not necessarily related to GDPR. This is related to licensing of data sets or other resources that you publish. The most common open license used in practice, to my knowledge, is Creative Commons. And this is just a brief overview of what Creative Commons does. It's a standardized set of licenses, and you can find it under the link I've put at the bottom there, creativecommons.org. They are adaptive, so you can have various combinations of different kinds of allowances in it. The thing I publish my things under is CC BY, which means that the work can be used for anything, so long as you attribute the source. So you can take the data, you can do with it, you can make a business out of it, but you have to acknowledge where it comes from. Less common is a restriction for the resource to be used, but not commercially. That sometimes causes issue, because commercial use could be used simply if you have an advertisement on your website that would already be commercial use, and that would mean you're breaching the license. So I would be careful with that. Very common again is share alike. So you could publish something as CC BY SA. That would mean it's Creative Commons, you have to attribute the source, and you can only share it under the same license. So you can do whatever you want with it, you have to attribute it, and you cannot publish it under another license. So you can't make it non-commercial if you've used something with a share alike license in there. And then lastly, you can say ND, standing for no derivative. So you can use it, but you cannot adapt it. So that would be, I don't know, you can quote it, but you can't reword it or something, whatever the resource may be. That depends on the individual case. But this is a common set. We'll share the slides, so this is probably more relevant for you to refer to later on, rather than me talking through in detail. And this is the end of my part. I don't know, Esteban, Ilaria, who is next, and whether you want to share slides yourself or want me to keep skipping through.
I just only one comment, because by default, if you imagine that you publish data in your website, etc., or any creative work, okay, by default there is a copyright. Yeah. So please, if you need, for example, if you want that your data set are open, please put a license. You have to specify the Creative Commons license.